Hello, everyone. My name is Paige Murata, and on behalf of US Law Network, we welcome you to this US Law Remote Learn webinar. US Law Remote is a series of virtual offerings ranging from our podcast to roundtables and more. If you'd like to learn more about these offerings, please see the link that I'm about to post in the chat. Today's webinar topic is the role of the truck driver. Since this session is set up as a webinar, your microphone and camera are turned off, but you can use the Q&A feature to post any questions and comments, and our panelists will answer them as they come in. We do want this to be interactive, so please be sure to utilize that feature. Now I will turn it over to our three member attorneys and allow them to introduce themselves.
I'll start. My name is Trey Sandoval. I am with MehaffyWeber in Houston, Texas. Excited about the opportunity to present with both my esteemed colleagues, Bryan and Nikki. And I'll just say something before I turn it over and let the other two introduce themselves. Feel free to put comments and questions in the remarks section, and Paige will highlight those for us, and we'll bring it up. We'll transition from each topic, subtopic, and before we transition, we'll see if there's any questions or anything that comes out. So again, welcome and looking forward to the next hour with you.
Bryan, do you want to go or do you want me to go?
Go for it, Nikki.
Okay, my name is Nikki Harlan, and I work for Carr, Allison in Gulfport, Mississippi. I practice majority trucking litigation. I also practice premises liability. I'm excited to present this with y'all today and excited to be presenting with Bryan and Trey.
Thanks, Nikki. My name is Bryan Price. I am with Flaherty, Sensabaugh, Bonasso in Charleston, West Virginia. We've got multiple offices throughout the state, but I'm based in our home office in Charleston. Looking forward to spending the next hour with you folks to talk about the role of a truck driver in litigation. Just kind of a precursor. The truck driver, in my opinion, can be one of the greatest assets in litigation if the case gets that far. But likewise, the truck driver can be your greatest liability too. And as we go through the presentation today, we're going to talk about those differences. What puts you in the category of asset or the category of liability? And we hope to give you a flavor of what we see, what we think are best practices, and different perspectives on different topics.
Perfect. We'll go ahead and jump in. Let's see. Maybe. Let's do this. I'm going to turn this off for a moment. Nikki, why don't you, or Paige, if you have that available, why don't we just turn that on? But we can jump into this as we.
I think I've got it up. Let me see if I can pull it up.
Okay.
And I was wrong.
All right, I'll give it a shot. No worries. Give me 1 second.
Thanks, Paige.
Sorry about that, guys. As we're getting this set up, I'll just give a quick intro into it. We had the opportunity to, Bryan and I got the opportunity to present in Nashville. Nikki was unable to join us due to, I think, illness, right, Nick?
Right, I had the flu.
Yeah, and so in Nashville, we got to present on this topic. And Paige, if you'll just go to the first slide for us, that'd be great. And we talked about this, and this is probably one of the best discussions we've had in a while, just about some of these factors. And as Bryan said, and I preach this all the time, is that obviously our truck driver is one of the most critical aspects of each one of our cases. And I'll give you really three truths that I live by as we defend and handle many of your cases that are on this webinar today. The first is that I don't care how honest or how amazing my drivers are, which I've had some outstanding ones and I've had some ones that have been very challenging. I have yet to have a driver that has told me the complete truth about the accident. And I talked about this with my colleagues yesterday that are presenting with me. And even the best ones, the ones that I looked at that kind of treated me like I was their grandson, and walking me through things, being very thankful for everything that they're doing. The fact of the matter is this, is that one, they're not going to tell you everything that's in play. And the reason for that is because we're typically dealing with one of the worst days of their lives, especially if we're dealing with fatalities. And when you're dealing with someone's worst day of their life, as you can imagine in your own context, you don't want to relive it over again and have to deal with it. And so it's not something you enjoy. It's not something you like doing. It's something that you force yourself to do. And it's certainly that experience with these drivers that I've prepped over the years and gotten them ready for, again, what is always one. Not only was the accident one of the worst days of our lives, having to be deposed by, a plaintiff attorney who is aggressive, approaching it from a reptilian approach, and just really putting the screws down to your driver. That's really going to be one of their, probably the second worst days of their lives, if they have to relive that. So as we're talking about that, one of the things that I think that as we've discussed this is there's several subtopics here that we're going to discuss. And that first role is the pre-litigation factors. One of the things that we do is immediately establish the attorney-client privilege, getting to know our drivers, and getting them on board and starting to build rapport. I know yesterday, Bryan, you had some thoughts on that, and why don't you toss in, and Nick, I know you have some thoughts on that as well.
Well, a couple things. First, from the practical side of establishing the attorney-client privilege early is exactly that. You can insulate your investigation into the accident if the attorneys are involved and the attorneys are running the investigation. You can basically assert attorney-client privilege to any aspect of that investigation if the attorney's running the show. But to Trey's point about those drivers, can't emphasize enough about how difficult it is for your drivers. And even if you get a lawyer out to the scene of the accident, or if the lawyer gets involved sometime later, post-accident, lawyers are oftentimes not liked or not viewed as people. They don't open up to us oftentimes, so we have to take extra steps to build this rapport. From my perspective, I reach out to my drivers as quick as I can. The first conversation I have with them, unless I end up at the accident scene, is going to be a telephone call. And then I try to meet with my driver as quick as I can. That's sometimes difficult to get scheduled, but I think face-to-face interaction is critical, because they start to see us as people, we see them as people, and when you've got that type of relationship, you're going to get more information. They're going to be more candid with us. They're going to be more open, more sharing, and have conversations with us, as opposed to us just sitting there grilling them with question after question. I personally will, after I make contact with my driver, I will set periodic calendar entries to remind me to reach back out, 3 to 4 weeks out, so I can just have a conversation with them. I call and check up on them. Oftentimes it's nothing specific to the case. It's just to see how they're doing, see if anything's changed, see if anything maybe has been triggered in their memory since we last talked. I also make it a point to try to humanize them. If I've got, depending on the timing of things, if one of my reminder calls is approaching a holiday or something, I'll just call them up and ask them, say, hey, how are things going? You got anything planned for Thanksgiving's next week, or Christmas, or whatever the case may be? And just have a conversation with them. And then what that does is it helps those drivers see us as people. So when it does come time to actually get into the nitty-gritty of discovery or deposition prep or anything that we might be doing as part of our investigation, they're open to talk to us. I have some drivers that no matter how hard I've tried, they just didn't they didn't want to have that type of relationship. And I've had others that, like Trey mentioned, treat him as a grandson, and they put their arm around you, and after you have a meeting, they want to shake your hand or give you a hug or a pat on the back because they really appreciate the assistance that they're getting from the lawyers who are, trying to help them in a very bad situation.
Bryan, I agree. Building that rapport is very important, but also maintaining that rapport is very important. Like Trey said, this is the driver's worst day, and we deal with this all the time. So sometimes we can become kind of cold to it. And I think it's important to empathize and understand where they're coming from because they can be defensive. Because they're worried about their job and they're also upset that someone was hurt because of them or because of an accident that they were involved in. So again, humanizing them and coming from a human standpoint and understanding them and letting them know that you're a likable person, you're a trustworthy person, and that you're there to support them and their needs. And I think it's important to like continuously update them. Sometimes you forget after discovery is over that they may want to continue to be involved in the case. And I had somebody reach out and didn't know that somebody had settled their case. So it's always important to keep them updated because they are worried about it.
As we're going through this, if there's things that are being stimulated in your mind as far as questions or anything that's happening, feel free to post that in there, and we'll call on Paige here in a second before we transition. But let me just kind of bring this topic to a little bit of a close, and we can transition to our next. One of the things that we're going to talk about, and there's a couple really pertinent things that we didn't even talk about in our prep call. I don't know if you saw yesterday or the day before, President Trump had, through the Secretary of Transportation, creating a situation where drivers are going to be held accountable for their speaking English. And coming from Texas, I'll tell you, I deal with that on a consistent basis. There's a lot of things going on within the state, obviously the condition and the political climate that's currently happening. One of the things, if we do not establish early in this litigation process, pre-litigation, if that's when we get it, and definitely when litigation starts, we have in Texas specifically, and I know this probably happens across the country, if we don't have that connection, we're going to lose it. And these other factors that are going on right now that are putting pressure, I have probably no less than 10 or 15 drivers right now that have self-deported. They're in Mexico, and staying in contact with them has been very difficult. And trying to do discovery, trying to be able to defend, trying to get their depositions, trying to do those things in the context of that has been very difficult. So as I can't agree more with what both Bryan and Nikki said on this, and just understanding that creating of privilege is important. Getting that driver on board and knowing that what you're going to need him for and defending that case. And we're going to talk about that in a couple nuances here in a moment. And then, of course, just building that rapport, and Nikki and Bryan both focus on the fact that we need to stay connected. You just can't have an initial interview with your driver and then try to go visit with them 6 months later once a deposition is going to be noticed or something like that. Paige, before we transition out, is there anything that's come up in the comments or questions that we need to address before we go to the next topic?
Yes, we did just get one. How does the involvement of in-house attorneys from the motor carrier affect attorney-client privilege, if at all, when it comes to involving them in communications with the driver?
Okay, that's a good question. And in fact, I dealt with this yesterday. So attorney-client privilege, it does not have to be outside counsel. And again, I'm speaking from the context of Texas. I assume that is the basis. So Bryan or Nikki has different aspects in their particular states. But as a general rule, if there is an in-house counsel and you get involved and your name is on the correspondence and you're on the email and you are on the calls, attorney-client privilege can be created. And then certainly there's attorney-client privilege that is created once we are outside counsels involved. So if the question is about, does that create the privilege? It certainly does in Texas. And the fact that in-house counsel for these large motor carriers, which does happen all the time. In fact, I have several clients that do that specifically for that reason. And I've even made suggestions in the past. For instance, when we get a file from some of my clients, it actually has surveillance and all these other aspects that have been worked up by the risk professionals. And what I always make a mention to is, if it's better to have an attorney on that in case we want to withhold for some reason, there's different privileges that come into place. But to specifically answer that, in-house can create that privilege, certainly when you're dealing with those attorneys like us on the outside, that will create that as well. Nikki, Bryan?
It's the same here. And I also, if you just, regardless of privilege, if you don't want to hire an attorney early on, or you don't have in-house counsel, an independent adjuster getting involved super early is a great option to build that rapport. It also, having the carrier, someone with the carrier contact the driver, is another option to build that rapport. I know that the privilege is important, obviously, but sometimes not everyone thinks that hiring an attorney immediately is necessary. But it is when it comes to privilege.
I agree. You know, in the in-house counsel role, we always assert that so long as the communication was made in anticipation of a litigation, we always assert that privilege. Now, I'll be frank and tell you that in West Virginia, if you ever assert attorney-client privilege, you're likely going to end up in front of the judge on some type of motion to compel, because the plaintiff's bar doesn't like that objection and they try to challenge it at every turn. We have some judges, within West Virginia who are sticklers for it, and they'll uphold that privilege as far as they possibly can. And we've got other judges that, will take the approach of, well, we'll just let them find out what's going on, what they want to know, and then we'll see where that takes us. So, I've been in the same venue before in front of different judges and got completely different rulings. So it just depends. But you absolutely, if you can establish it, if you can create the relationship, there's nothing but benefit that can come from it.
Right. It gives us a lot to argue once we proceed. Paige, anything else that we need to address before we move on to the next topic?
Nope, that's it.
Okay, let's move on to the next subtopic. All right, Nikki, do you want to tackle this one first off, and then Bryan and I can follow you?
Yeah. Participation in discovery by your driver is super important. Like Bryan and Trey have said, your driver is critical to the discovery process, and to the defense of your case, and that is established in the written discovery and in depositions. Personally, for me, I have found that drivers are hard to tie down because obviously they're on the road all the time. So I try to make it as easy as possible for them in written discovery. When interrogatories and requests for production are propounded on them, I immediately contact them, ask them if they have access to an email or printer, ask them if they prefer a phone call for me to read the questions to them. Sometimes they're on a break and they have time for that. I want to make sure that they get a copy of it. And if they don't have access to a printer or email, which oftentimes is the case, I try to use the employer or the company that they're working for, see if they can kind of facilitate that. Often, if they're no longer with the company, I ask them, I'll send them the interrogatories in an envelope with a return envelope stamped already in there. I try to make it as easy as possible for them, again, because you want to make sure that they know that you're on their side. Sometimes I even have a paralegal meet them to go over the discovery, wherever that is. Sometimes it's an hour away, 2 hours away, but as long as it gets those answers started.
I agree, Nikki. And, this kind of goes hand in hand with the rapport that you build with your driver. Before my driver ever even sees a set of written discovery, they know it's coming. They know it's coming because I've told them it's coming. And if I've got a driver that I've got a good relationship with because we started early on and we've maintained continuous contact, they know what the written discovery is. They know what their obligations are going to be, and they know how we're going to work our way through the process of getting responses prepared and submitted. If I've got that driver that I've got a close relationship with, I can tell them, say, hey, I'm just going to send you a document that's got a bunch of questions on it. And if you will, when you have time, jot down some answers to it. And then once you get to the point where you think you've answered whatever you can, then, we're going to set up a call, or we're going to have a face-to-face or a Zoom or Teams meeting, and we're going to go through your answers and finalize everything. That's with a driver that I've got a good rapport with, that has come to trust me and understands what the process is going to be. For those types of drivers that I don't necessarily have that rapport, maybe I didn't get involved in the case until after litigation was filed, I typically make it a practice to meet with them face to face to go over the discovery, because until a recent revision to our rules of civil procedure, there was no limit on the amount of discovery you could send. So oftentimes you get a packet of 50 questions, multiple requests for admissions, multiple requests for production of documents, and it can be absolutely overwhelming to a driver to receive a packet of 100 pages in the mail and not really understand what it is or know what to do with it. So I will, in those circumstances, make sure that that driver is not looking at those discovery requests without either myself, an associate, or a paralegal looking at it with them at the same time, so that they get a level of comfort and they're not just completely overwhelmed with what they're looking at.
The last thing that I'll mention on this topic, and obviously before any questions or comments that come into the feed, transitioning just from written discovery to the deposition process, which we're going to have a specific topic about this, is, again, I come from a very psychological metric-based background. And one of the things that I always try to look at, and the way that I break it down is, especially when you're dealing with fatalities. Fatalities has a very significant impact on our drivers. And I've noted that for obviously the last decade of really trying these cases and getting involved in those. When you're dealing with those, what I have found, even through the written discovery process, that if we know we're defending a case that's going to have a very large demand, or there's a lot of damages, and certainly if there's fatalities involved, those damages are going to be very high, and liability is, it doesn't even, certainly in situations where liability is, where we concede liability, but if it's contested, even in those situations as well, what I have tended to do, and it's been very economical under the circumstances when you look at it from a relative basis, is get a jury consultant involved when we're prepping our witnesses for depositions, which we're going to talk about a little bit more here in just a moment. But even at the outset, when we're talking about these themes and defending, and again, I'm coming from, not West Virginia, I know is extremely challenging. Plaintiffs have a very good venue there. Mississippi, where Nikki is, in fact, I keep hearing all of these things that are argued in our legislature that say that the defense wants to be like Mississippi because of the caps and in certain situations like that. Texas, we don't enjoy any of that. And as all of you know, that if you have Texas-based cases and you understand kind of the war that we have every single day with plaintiffs' counsel on inflated meds, on dealing with jurisdictions where the judiciary far out favors plaintiffs' motions. We barely get any kind of relief when we're asking, and I can tell numerous stories out of all the major counties here in Texas. It is critical that we start thinking about the preparation and participation and discovery of our driver very early. And I've gotten Christina Marinakis, who is with Immersion, one of our partners with USLAW. She's had her team come in. I've had it multiple times come in and help prep for depositions, but I've also started using just some thoughts on how to talk about this, because once I've gotten her involved in one of her team members when we do interviews with the driver, because it kind of builds this team and again continues to build that rapport. So again, just another little tidbit on top of just the written discovery that we've talked about. Paige, is there anything in comments, anything that we need to address before we go to our next topic?
We do have one question. What happens if a BCO does not cooperate?
What happens if a BCO?
Correct.
Okay. Help me, guys. Am I missing BCO?
Yeah, what does BCO stand for?
A
And maybe,
person could specify what they mean.
and maybe I'm just not catching it right off the top.
I don't know what it means either.
The BCO is the driver.
Okay, all right. I just wanted to make sure. I assumed that, but I didn't want to assume. So I tell you, I have numerous drivers that do not want to participate. And depending on the case, and there are some things that happens with the case, I try to be very, as Bryan said at the outset of this, when you're trying to build that rapport and you're trying to talk about that, and Nikki in the same manner of sitting and reminding and trying to check in between even what Bryan said on holidays, if they are completely uncooperative. In Texas, there's some unusual ethics opinions that have come out that prohibit me from really notifying anybody of that, because as an attorney in Texas, I can do nothing that would put my client's coverage in jeopardy. And so what I try to do is we have multiple people. We have several Spanish speaking attorneys on with my team. A lot of my drivers are Spanish speaking. We try to build the rapport. That's really where I find the most difficulty is with our Spanish speaking and those from Mexican descent that, as I mentioned earlier, that have self-deported or maybe have questions about their status in this current political climate. Honestly, there is not a hard and fast solve for that. It really is individual. I try to address whatever their concerns are. And I'll tell you what I find out is the most often concern is it's the ostrich effect. That's what I call it. And I have even some of my associates email me and say ostrich, meaning that it's a driver who just is so litigation averse, so lawsuit averse, lawyer averse, that they don't want to talk, that they're fearful that it's going to impact them somehow financially. We obviously deal with that. But we just try to reach out to them on a consistent basis and try to address whatever their specific concerns are. But I'll tell you, that's about a 50% success rate. If they choose not to participate, then there's not much we can do. We send letters, we correspond. If we can't find them, I've used martial investigation to identify them. We send a letter. And again, those letters are written in a very informal manner, telling them that we're here for you and we want to be able to defend. You're not financially responsible. Nikki, Bryan, any other thoughts on that?
I think also the company encouraging them to cooperate is very important as well, because in Mississippi especially, it can affect the liability of the case. I mean, we're a comparative fault state, so their testimony is so important to liability, because otherwise we only have the plaintiff's version of events if they're not cooperating, and then we don't have anything to support that the plaintiff was even 1% at fault. So I always try to encourage that the company, if they are still with them, obviously that changes if they've been terminated, but if they are still with them, then I like for the company to encourage that as much as possible and maybe even have them attend calls with the driver.
Yeah, and there's really two different scenarios too. There's situations where the driver is actually a named party to the litigation versus situations where they are not. If they're not a named party to the case and there's discovery that perhaps you need some assistance from the driver and you're not getting it, that is that's less of a slippery slope. You can massage that to hopefully get responses to opposing counsel, and they don't push back too much. The bigger problem is when that driver is a named party in the civil action. That creates problems for us lawyers, to be frank. We have ethical obligations and duties that we have, and as Trey mentioned, we get backed into the corner. We can't be answering discovery on behalf of the driver when that driver hasn't participated in giving those responses. And in West Virginia, the driver has to sign an affidavit swearing that the responses are, putting those responses under oath. So we can't be answering discovery on behalf of an absentee driver. So that gets us in a tough spot. I've had success a couple of times convincing opposing counsel that, and it was a strategy call that we made with the employer client. We convinced the plaintiff's lawyer that he didn't need our driver as a named party, that he was, the company was going to take full responsibility for the accident and whatever damages that would be awarded in the case, if any, the employer was going to take care of. And we avoided a bad situation by getting plaintiff's counsel to agree to let the driver out individually. That's not always a possibility. In fact, it's probably the exception as opposed to the rule. In which case the lawyer may be at some point in time forced to withdraw his counsel for the absentee driver, which could ultimately lead to default against the driver, which may turn it from a case of disputing liability to strictly a damages case. So that kind of takes us full circle to, the opening question: what is the role of that driver in litigation? The role of the driver is absolutely necessary. Without a driver, it can tie our hands as counsel for in the litigation. So we need those drivers, and it's a tough situation if we get one who doesn't want to cooperate or just can't be found.
And that's why that building rapport is so important, because you want them to understand that you represent them just as much as anybody else, even though you've been hired by the company or the carrier or whoever. You want them to know that you represent them in their interest as well.
The other little tidbit that I'd throw before we go on to the next topic is that I look at it as a crescendo. So I start off as nice as I possibly can be in the rapport and the aspects. And obviously, as Bryan even just mentioned, the aspect of withdrawal. I've had to withdraw a couple of times, and it does create that default. It does create a situation where it changes from contested liability to just a damage case. And by the time that I get to the end of that crescendo, where I'm getting more stern and more terse in my correspondence, I typically outline all the times that I have contacted them via telephone, and if they have a text or emails, and I try to document that all the way through. And again, if we've lost them, I've had great success with Marshall finding some people, and even having one of their investigators go actually hand a letter to them that's from us. Usually, if it's Spanish speaking, we write it in Spanish and give it to them and say, look, we're here to help you. This is not going to impact you financially, because again, that's the number one reason why a lot of people don't want to participate. The number two reason is that they're afraid of the litigation process, and then three, obviously all the other issues if they have some issues with citizenship, which again I deal with all the time in Texas. So.
Sorry, Trey. They're also very annoyed by the process, especially if it's an accident that they deem minor and they don't want to deal with it. And if it was 3 years ago, they don't even hardly remember it. And the lawsuit's just now being filed, and they've moved on to 2 other different companies, and they're annoyed with having to participate at all. And I find that often.
Good point. Paige, anything else that came up before we transition?
We did get a follow-up question, yes. In what instances would you recommend the driver retain separate counsel from the motor carrier that hired him or her?
Well, I can tell you where it comes up most often is if there is something that is outside the course and scope. For instance, they were drinking, or if they were using drugs. That's what happens the most often. Because that creates an adverse relationship between the motor carrier and their driver. And that is probably the most primary situation. There are a few others, as we all can expect, and all of us know, because we all do transportation on this webinar, and certainly those that are participating, that drivers are typically not going to be sophisticated in the fact of they're thinking that they need to go get another lawyer. They're hoping, and financially they don't want to. Maybe they don't have the means to do so. So if that happens, then obviously there's something that's creating an issue. And for us, it usually means that it's outside the courts and scope. Bryan, Nikki, you think of
I've
anything
had
else?
I've had it when the driver basically is blaming the company for whatever happened in the accident, whether it be his training or some mechanical issues or whatever it may be. That's another point that creates an adverse relationship between him and his company.
Yeah, I agree with both Trey and Nikki. Obviously, the situation where an employee driver is being terminated as a result of the accident, or maybe even something unrelated to the accident, there is some adversity between the driver and the company at that point in time. And then separately, always a possibility that the driver is going to try to assert that the accident wasn't their fault. They weren't trained on a certain thing, or maybe some type of mechanical failure contributed to the accident in their mind. And if you've got a driver pointing the finger back at the employer, absolutely there needs to be discussions about separate counsel being retained for the driver.
So probably the best rule of thumb to answer that specific question is that anytime there creates an adverse relationship between the driver and the company, that is a situation where I would suggest you evaluate whether or not separate counsel needs to be hired.
And
Paige,
when it's
anything else?
adverse,
Oh, sorry.
and when it's adverse to you, I've had a driver after he'd been terminated text me in the middle of the night and say a long 3-paragraph text, clearly after some drinks, that he didn't trust me, that I had the company's interest in mind, and that he no longer wanted me representing him. That is very clear that that adverse relationship and was created by that text. And so I no longer represented him after that and withdrew.
No point. Paige, anything else?
Yes, another one did just come in. If the
Okay.
insured and the driver are not responding to communication from their insurance company and are completely unresponsive, can the insurer refuse to provide legal representation?
Well, so that's a coverage question, and all three of us, I can see us smiling on this, is that we'll say that's a question for your coverage counsel, because we are the underlying litigation. You hire us to represent your drivers and the company in the litigation once you get sued, or certainly in a pre-suit. When you're dealing with coverage, because that is a coverage question, whether or not they participate, whether or not there's any type of covenant or endorsement or specific recital within the policy that says that they must cooperate. Again, I don't even touch that in my practice. I treat that coverage as a completely separate and apart, and I pretend that it doesn't even exist. My job is to do the best I can possibly do to represent and get the company and the driver out completely, or obviously for a reasonable settlement. So to specifically answer the question, if they're uncooperative, I have definitely seen carriers and insurance carriers pull coverage on that. It doesn't happen that often, but again, I stay out of that completely. Bryan and Nikki?
Yeah, that has to be a decision that's made by someone other than counsel who's been retained to represent the interests of either the company or the driver. As the lawyer for either, we can't make that decision. And as Trey previously stated, we try to stay as far away from that as we can. We represent the insured at the direction of the carrier until we're told not to, and that decision has to come from somewhere else. And I
Nikki, anything?
personally don't do any coverage work, so.
I don't either, Bryan. And I prefer not to. I've had it where I know that the carrier is sending non-cooperation letters to my driver. I'm not involved in that process whatsoever. I just relay the information that, hey, he's not responding to anything.
Little tidbit of this, and then we'll go on to the next topic so we can try to make through a couple more here, is I'll tell you, if you ever hear from me, and certainly in Texas, and I think there are other, as I remember reading the ethics opinion on this, I will be very light on my communication about the non-cooperation of my driver or my company. Because again, pursuant to the ethic rules that I'm obligated to and certain ethic opinions that have come out in Texas. If there's ever anything that's light in any of my reporting or our conversations, you will know I am specifically trying to walk that line of not taking any affirmative action that would put or create a situation where my client would lose coverage. And obviously cooperation is one of those provisions. So just a little tidbit on that as well.
Trey, can you give an example of that, like what that light communication would be?
Sure. In most of our status reports, we have a client interview, and it says there, and I typically, my light means that we've made multiple attempts to try to contact Mr. Smith. Mr. Smith initially responded to a text, or we originally spoke to him on this date. However, we've attempted to contact him multiple times. Should we be able to reach him in the future, we will provide an update. That is basically as much as I can put in writing. And
so you try to avoid using words like he's refusing to cooperate or to communicate.
I never use cooperation at all in any correspondence. And I never say refusing. I just say what we've attempted to do and that we will provide an update once we reach that person. And again, I know both of you probably do not have as strict of rules, because this has been an issue in Texas probably about 4 or 5 years ago. And there was a very strong ethics opinion that came out because a lawyer got sued by his client as a result of losing coverage because there was communication to the carrier, and that communication was utilized as a basis when they denied coverage and walked away. And so therefore, that's where all this comes out. I will even walk into a courtroom when I'm dealing with what Bryan was talking about as far as withdrawal, and I will have to say, Judge, may we go off the record? I don't want a record. I don't want anything that would create that situation. And I'll say, Judge, I'm just unable to represent my client any longer. And Judge, I ask that you would sign this order. Most judges in Texas now, because of that ethics opinion, and there's a couple of cases that have come down on that, understand that. And will certainly support an attorney as an officer of the court when they make that request.
Well, it's a tripartite relationship. The insurance company hires us, but our obligation is to the insured. That's where the attorney-client relationship exists. So all of the ethical standards and obligations that we as lawyers have to comply with, those are owed to the insured, not the insurance carrier.
Not the carrier.
That's right. Obviously we've got different concerns, different obligations, and a business relationship with those carriers. But when it comes right down to it, the ethical obligations that are imposed by us, by our practice, and our licenses to practice law, the obligations go to the client, which is the insured.
All right, Paige, let's go ahead and jump to the next topic just so we can make sure we have about 15 minutes here. Driver preparation, be prepared or prepared to fail. This is something we talked about a little bit earlier. And again, one of the things that I think is extremely critical in every deposition with a driver is that driver's deposition is usually one of the main things that plaintiffs will argue as far as value of a case. That is certainly present in Texas multiple times. I know that's present in multiple jurisdictions. And therefore, when we do an evaluation of this, one of the things that I often put in there, because I've been told in the past, and honestly, this has been something that hasn't happened lately. I wouldn't say in probably the last 6 years, 7 years. But there was definitely restrictions put on me early that says, okay, do you need to meet with your client in person? Can you do it by phone? Trying to limit some of the expenses and costs. And I will tell you that the investment in prepping our driver is probably one of the most important investments that we will make in the entire case. And therefore, it goes back to what I started off at the outset, talking about how we hire Christina Marinakis' team to come in and assist us. And just to let you know, that's about a $5,000 spend, not that much, to prep a driver. And when you're looking at a $1 million demand, or you're looking at a tower that's up to 9 figures, that $5,000 comes back tenfold sometimes. Because we prep them, you get an angle from a jury consultant who has, again, that psychological basis that assists us, and we're on the legal basis. And I have found, especially in fatalities, that if we prepare, meaning that you have initial call with them and you're getting ready for a deposition, usually, and again, we all hope that our clients have Zoom and the ability to go face to face, but I'll tell you, most of my drivers can barely use their cell phone, much less get on a Zoom or even know what Teams is. And so that's usually a call. And then typically we go wherever they're at, sit down with them face to face. That's the second time. And then I usually leave at least a week between that prep session and the deposition in case we have to schedule something else. And we usually have something tentatively scheduled in case that's needed. And again, it takes this much to get ready for, because again, I deal with reptile every single day in Texas, and the judges are letting it go rampant. And I need to get them exposed to all the information, talk about it, go through all the emotions, watch the dash cams, look at their discovery responses.
Bryan, I think Trey's frozen. Is he
I-
frozen on your end?
I was going
Okay.
to say he's frozen on my screen.
Okay. Well,
Uh,
I can pick it up from there too. I think it's important in a deposition to prepare them on how plaintiff's counsel is going to be and how aggressive they will be. I know some plaintiff's counsel
Properly
Mississippi.
prepared.
Oh,
Go
I'm
ahead,
sorry,
Nick.
Trey. You froze for
Oh,
a
no.
second, and I tried to pick up from there. But I think that letting them know that plaintiff's counsel is going to be aggressive, is going to be offensive, is going to try to trip up your words. Letting them know that on the forefront helps prevent them from becoming mean and angry and defensive during the deposition. Because that's what the plaintiff's counsel wants to throw them off their game, wants them to be angry because it doesn't look good. Another thing that you want to talk about, you don't want to be surprised by anything in the deposition. So you want to make sure that you've covered everything that happens in the accident. You want to cover their background, whether they've been arrested for anything. Again, like Trey said earlier, they're not always honest with you. And then it comes out in the deposition because they feel like they have to answer honestly because they are under oath. So you try to encourage that you want to know the bad information as much as possible in the forefront so that you know how to properly prepare for it during the deposition.
I agree with everything Trey and Nikki has said. I can't express how important the prep is for the driver's deposition. I don't think that you can ever be over prepared. And sometimes there is a request to limit expenses in prepping drivers, and I understand and appreciate the economics of all that, but to adequately prepare a driver, in my opinion, now obviously depending on the scope of the accident, what kind of damages are being claimed? Is it a wrongful death or is it a property damage, case only? But driver prep is days, not hours. And I often employ a friend foe type of approach, and this assumes that I've got a driver that I've got a good rapport with. My first conversations with them are in depot prep is, generally talking about how the deposition is going to proceed, having them tell their story again, making sure that the narrative that we want told, the buzzwords that can help our case are fully ingrained within the driver, and we'll spend hours, full day, talking about things like that, going over the accident report, looking over any dash cam footage that might exist, looking over discovery responses, policies and procedures that maybe the employer has published, talking about the good, the bad, and the ugly, everything, but as an advocate for the driver, because not in every case, every deposition I've defended, there are some warts, and you got to be ready to deal with those warts, and you need to make sure that your driver is in fact ready to deal with those bad facts. And then what I will do after that is we'll do like a mock deposition. I'll take various topics, and I will examine my own client as if it's a real deposition scenario, and I don't go easy on them. It's like most plaintiffs' lawyers do. You start out easy. They try to build a rapport, and then they start really going at them. And, you know, a lot of my clients will say to me after day two, the faux day, if you will, you know, holy smokes, I thought we were friends. And they're a little turned off by how aggressive I was. And I said, well, you know, this is purposeful. This is the reason I'm doing this, is to prepare you for your deposition. And then we go back to a friend day and we talk about how aggressive I was, how my aggressive tactics actually worked in my favor. I got them to admit things they didn't otherwise intend to admit. I got them to not fully explain their answers because I was cutting them off. You know, all the tactics that you're going to see used in a deposition by the plaintiffs. We go through that, and in a friendly way, we talk about how those things could better be handled in the deposition. And then we'll go back to a faux day where I'm aggressive at them again, and we gauge how they've improved from the first faux day to the second faux day. You know, now they get it, they appreciate it, they understand how the plaintiff's lawyer is going to be coming at them. So we'll do that as many times as it's necessary in order to get them as prepared as they can be for the deposition. And like I said, no matter how much time you spend with them, you are never going to be 100% prepared for these depositions. Your witnesses are going to say things that you didn't know. It happens. We were talking about it the other day when we were prepping for this. Trey was telling the story of a witness who, I can't remember exactly what it was, but after days of prep, they said something in their deposition that he had no idea was even a fact. So you can do the best you can, and there are ways to do that. It is going to be a long and tedious process. And to the employers out there who may be listening to this presentation, I would encourage those employers to do whatever they can to help facilitate the lawyers to have these extensive prep times. You know, these guys are drivers. They're not making money unless they're on the road. I actually had a case recently where the company gave the driver PTO days to meet with me. And, you know, that helped because he didn't feel like he was, you know, missing drive time where he's making money. He wasn't being financially penalized. And in the end, the amount of time that he spent with me over those few days getting ready for the deposition ultimately inured to the benefit of the employer, because the reality was they're the ones that were on the hook for the liability. So to the extent that the employers are able to help facilitate those types of meetings and those types of prep sessions, it's a win-win.
I've even had an employer schedule a haul or a load near my office or where the deposition is going to be and the prep is going to be. And that helps get them here because, again, like Bryan said, they're concerned about money.
That's a great point. You know, just to wrap, and we have a hard stop here in about 2 minutes, 3 minutes. Again, it's been a great opportunity to share with you. An hour always goes by very quickly. Again, I can't tell you how much of a privilege it is to represent not only the many companies that are on this webinar, but the others that are not, and certainly the drivers. Paige, is there any other final question in there that we can address here for about a minute or two, and then we'll...
Not right now. I'll let you know if anything pops up, though.
I think we might have lost
Okay.
Trey.
Well, perfect. Any other final comments, final thoughts, Nikki, before we drop off?
I don't think so. I think just, you know, going back to obviously the role of the truck driver and what Bryan said in the beginning, it's the most crucial role in the litigation and the defense of the case, especially when it comes to liability.
Perfect. Bryan?
I think that's a wrap. I appreciate the opportunity to talk to everybody. Obviously, we're available. You know, after this presentation, if people have questions, reach out to me, reach out to Nikki, Trey, all of us at the same time, and we're here to help.
Outstanding. Thank you so much for your time. Hope you found it helpful, and we'll look forward to talking with you soon. Paige?
All right, great. Well, thank you to our member attorneys and thank you to everyone for participating in today's webinar. We should have the next schedule of US Law remote virtual events out soon. And thank you. Have a great rest of your day.
Thank
Hey,
you.
Thank you.
Before we go, Paige, I think somebody asked a question about the video being posted. Could you?
Oh,
could you
yes.
just-
So we are recording this and the link will be available most likely by tomorrow morning and it will be posted on the website. But if you'd like me to send it to you as well, feel free to shoot me an email and I can send it to you directly.
Thanks, everyone.
Thank
Perfect.
you.
Thank you.
Thank you.